Please be seated. We will hear argument in case number 24-1049, Diamond Hydraulics versus GAC Equipment.
Good morning, and may it please the court. In a battle of the experts case on causation, the defendant had no experts, the plaintiff had two experts, one of whom had been specifically designated to rebut defense expert testimony. We think that there are three major errors that require reversal in this case. And the first is that the court did not consider the evidence before it of good cause, and the good cause is that the need to substitute in Dr. Horner was completely beyond the control of the defendant or its counsel. Second, did not consider the evidence of lack of unfair surprise or prejudice, and that is because they knew about every single opinion that was going to come out of Dr. Horner's mouth if he had been allowed to testify for a year. And we believe that that is enough to satisfy the second exception to 193.6. And finally, that the court didn't consider the impact on the defense of exclusion. And this is the really critical point, because the defense had its hands tied behind its back, was not able to explain to the jury its theory of causation. And this is super important in this case, because in this case, there's no evidence in the record to justify a presumption that a claim or defense lacks merit. And in that case, under Trans-American, we believe that due process concerns arose.
Can you tell me, just as background, what exactly happened on the day of the underlying event? The cylinder bent, it was lifting part of a bridge at that point? It was
lifting a 55,000-pound bridge. I think it was outside at the Austin airport.
Was it 55,000 or was 55,000 pounds the capacity?
I believe it was a 55,000-pound bridge. She's telling me that that's true. So the whole point of the trial was to figure out what exactly happened, right? All we know is we have a bent cylinder.
What happened when it got bent? Did the bridge fall? Did it cause some harm or anything like that?
Not that I'm aware of. No personal injury, nothing like that I'm aware of in the record.
Okay.
All right, so going to unfair surprise or prejudice, that can be met within three elements. We know that the parties had adequate opportunity to assess settlement, plenty of evidence there. They mediated unsuccessfully. The other side had the ability to prepare and present opinions from two different experts to rebut the opinions that were set out in the Nighthawk engineering report. And the whole point of this for unfair surprise or prejudice is to avoid trial by ambush. Letting Dr. Horner testify would in no way have amounted to any trial by ambush. Like I said, they knew the opinions. We stipulated, our defense counsel stipulated, you know what, we're not going to let him testify to anything outside the bounds of that report. In terms of timing, opposing counsel was informed 34 days before trial that Dr. Horner would need to testify because Dr. McFarland just left and quit and left the state. They offered his deposition at that time. They offered his deposition again in writing when they filed the emergency motion for leave to supplement. Austin just didn't take him up on that offer. And so that's for the timing part. Their argument is that Dr. Horner had different qualifications than Dr. McFarland. Dr. McFarland was a mechanical engineer. Dr. Horner is a metallurgist. Well, there are 2 points to that. First, their entire case is built on the strength of metal, and their initial expert is a metallurgist. So having a metallurgist as a defense expert is no surprise and no difficult wall to climb in a deposition discussing qualifications.
Dr. McFarland sat for a deposition,
He did.
right?
Mm-hmm.
And the other side asked him a bunch of questions in the deposition.
He did.
Your side didn't, right? Just passed questions for trial?
Yes.
Okay, so that was a strategic call. You could have locked in this testimony in the deposition. You just chose not to, right?
And I'll tell you, I've never done that. I never would. If I expect my testifying expert to attend a trial, there is no reason for me to cross-examine him.
Right, but except that you then take on the risk that something might happen to him, and then he's not available for trial.
And I understand that is the break the glass in case of emergency type of an option, right? And so that means in any trial, any case where I have a witness, fact, testifying expert, otherwise, I had better ask my questions as though it's a trial deposition, just in case they get hit by a bus and can't show up. And
did you try to get that deposition into evidence?
The deposition was not entered into evidence.
Why?
And there's several reasons why. It would have been wholly insufficient to present the merits of the defense and to explain. Dr. McFarland and Nighthawk, they did an entire root cause failure analysis.
Wouldn't it have been better than nothing?
That was a strategy call but at the same time, I understand because you want to be able to say that the deposition would have been enough, but the problem is it wouldn't have been enough. So would it have confused the jury even further than attempting to just cross-examine their experts? And that was a strategy call by counsel. But let me please, I understand the depositions. If you're interested in that point, I have several reasons why the deposition was insufficient to present the merits of the defense. And first of all, it's cross-examination, which is designed exactly to build down testimony, not to explain it, not to build it up, and not to make sure it's clear to a jury. When Dr. McFarland was being deposed, he was asked very tight cross-examination questions. He would try to expound and explain, well, this is what I mean, and this is why I'm saying that. And he'd pull an objection as to non-responsive from counsel, and that's in the record, page 1512 at volume 3 of the clerk's record. And that happened time and again. There were absolutely no specific questions on opinion 4. Opinion 4 was the causation opinion. They talked about 2, which had to do with spherical bearing, seizure, things like that. But that was not in the deposition.
All of this happened more than 30 days ahead of trial.
34 days ahead of trial, we found out that Dr. McFarland would not testify. He would not come in.
And so what if all of it had happened sort of mid-trial?
I think if it had happened mid-trial and we had him...
Still would you be arguing good cause?
I'm trying to think of a fact situation where we had him in Texas and locked down in a hotel room, wouldn't let him leave. If he had just left in the middle of trial and decided not to testify and I'm quitting, I'm out, or he was in the hospital or somehow otherwise incapacitated, I think we would have first argued for a continuance. And I think that would have been certainly preferable, even though it would have been unfortunate the trial was already underway. It would have been preferable to not being able to tell the jury anything about causation.
Would a continuance here have helped to depose the expert? And
yes.
Why didn't that happen?
The continuance was denied. A verified motion for continuance and/or for reconsideration was filed. It was denied. And our point is that, a lot of courts have talked about 193.6 being an automatic sanction and having only one sanction. And that's not exactly true. Because under 193.6c, trial courts have discretion to grant a continuance or a brief postponement of trial, even if there's no evidence of good cause, no evidence of unfair surprise or prejudice. And I think that that's the perfect place for courts to stop, take a pause, consider if this is merits preclusive and your entire defense is causation and I'm not letting your expert testify, maybe a brief continuance would be enough to get them there.
And on the, strategery, not going to question the witness at the deposition, strategery, decided not to put the transcript from the deposition into the record. One of the other things that's been suggested by a friend in opposition is that you could have done a Zoom, argument or a Zoom testimony from Dr. McFarland, even though he was outside of the subpoena range. How would a Zoom... would that have even been enough? Like, if we're talking about trying a case on the merits with our 12 citizens good and true, assessing credibility and everything?
I think that, our position is if you guys have a live testifying expert, we want a live testifying expert. That would have been perfect world type of a scenario. And I think opposing counsel before the court, when all of this was being argued on the 16th of September, that he even said, I understand there's a little bit of prejudice in not being able to have somebody there live for the jury. Obviously,
I don't have the same chicken trial court chops that we're talking about this, and I wasn't litigating very much during COVID when Chief Justice Heck and our court used Zoom to do a lot of these things. But is it your understanding either during that time or since then? Is it typically the case that you'll have a so-called Zoom testimony when you're trying a case in chief on the merits, or do those things typically come inside the courtroom?
I think it depends. It depends on a lot of different circumstances and availability. And honestly, if we had been able to get McFarland to agree to testify by Zoom, heck, we would have loved that. That would be great.
His affidavit is in the record, and it doesn't speak to that at all, right? I mean, I'm looking at it here, it just says that he now lives in Ohio, he doesn't have plans to return to Texas, and he's not available on October 3rd to testify in Texas. There's nothing in the affidavit that speaks to whether he can testify on Zoom or remotely or anything else, right?
He doesn't say that he would testify because he would not testify. So I understand that they've been picking apart the affidavit and the language used in the affidavit. He said, I'm not available to testify in this trial, and then the end of the sentence says on October 3rd is when it was scheduled to be tried.
But did he say testify in Texas in this trial, or did he say testify in this trial in Texas?
He said, I am not available to testify as an expert witness in cause number, fill in the blank, right, in the judicial district in Williamson County, Texas, set for a jury trial starting October 3rd, was the complete paragraph. He also said in the next paragraph that his engineering firm that he quit and counsel for Diamond have no authority to accept a subpoena on his behalf. And we also, when that affidavit started to get picked apart a little bit, counsel for Diamond came up and said, listen, we've called him, he did the affidavit as a favor, he's not coming back, he's left, he's got greener pastures, he's in Ohio, he's on to a new job.
He has no plans to return to Texas.
Zero plans, exactly.
I guess, I'm wondering, the good cause language in the statute, it kind of seems like that's putting this in the heartland of a trial court's discretion. I mean, the trial judge is there and, looking at the competing factors, yeah, you're kind of being sandbagged, but the other side would be prejudiced too. The deposition happened, there's other avenues, and the trial judge just makes the call. I guess I just don't see why 193.6 takes this out of that heartland of trial court discretion.
Right, and I think if we turn back to Alvarado, which really digs into the stricter showing of good cause under a Rule 193.6, formerly 215.5 analysis. In Alvarado, they were actually concerned, and Smith, which issued shortly thereafter, they were concerned that it tied the judge's hands way too much because it's such a strict standard that I think up to that point they had never found good cause. And so it wasn't until I think it was Smith when they said, listen, he's a named party. Maybe they didn't put his name down in response to interrogatories, but come on, he's going to testify, and they allowed him to testify. So that's been kind of the problem. Now, when it gets to judicial discretion, if it's this strict standard, we know that there are certain things that meet that strict standard. Hey, I was trying to find a witness. I was diligently searching for him, could not locate him. That justifies good cause as a matter of law. Under Clark, which was cited in Alvarado, same thing. If I would not be able to anticipate that this person's testimony would ever be needed, which is kind of our situation, that justifies good cause. We would ask the court also state that if you have circumstances that are beyond a party or their counsel's control, which this circumstances absolutely was, that is good cause sufficient to meet an exception here.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Polvey will present argument for the respondent.
May it please the court. This case is not about constitutional imperatives. This case is not about failures on the part of us and Crane. This case is not about a party who is precluded from putting on its case in chief. This case was about a party that repeatedly failed to comply with the deadline to designate experts. This case is about a party who repeatedly refused to offer the very evidence that it now says this trial court improperly excluded.
So is it true that the expert at the last minute said, I'm going to Ohio?
Almost, Your Honor. And in the affidavit, what it says, and I think it would be helpful to the court to review the entire thing, because it doesn't by itself establish good cause. That's on record 1241.
So why is it not enough to say, I have no plans to return to Texas and you can't accept a subpoena for me?
Because that's not sufficient good cause under the Farah versus Alvarado standard from this court to establish difficult or impossible circumstances. To Justice Sullivan's point, we offered to allow Dr. McFarland, who he himself was designated 540 days past the expert designation deadline, to appear by Zoom, to do a trial deposition by Zoom prior to the October 3rd trial setting. moving out of state to Ohio and switching jobs does not prohibit his ability to appear to a Zoom.
Not sure that that's the point that I was making, but maybe I was. But let me ask you this. Justice Hawkins asked about kind of the heartland of deference and Rule 193.6 looking something like that. And you mentioned, a couple of post-deadline, 500 days post-deadline, and then 900 days post-deadline. But with respect to the same deadline and the same T minus or T plus count, isn't it also the case that that you I think that for the first trial setting, the evening before the pretrial conference with trial set, T plus 7 days after that, that y'all dropped an expert in, and then everybody had to scramble the jets, get it done, and did?
Absolutely, Your Honor.
And so my first question is, from the same deadline that gets you 500 and something for Dr. McFarland and then 900 and something for Dr. Werther, how far past that deadline, how many days past that deadline were you?
It was probably several hundred days as well.
Okay. So that's why I asked about Justice Hawkins' question about deference. Definitely deference, for sure, but we have said that an abuse of discretion includes doing something that is arbitrary, right? And so I guess the only thing that comes to mind is Rodney Dangerfield in Caddyshack, who's like, "Hey, judge, keep it fair." And how is it that the conscientious district judge kind of lets y'all off the hook for blowing the deadline? And would you say it's fewer? I guess it's fewer than 500 days. You said maybe 200. Just say
it was probably several hundred days at that point.
Right. So you get off the hook for that, and everybody scrambles the jets, and then they don't get the same treatment, or is it they got 2 strikes and you're out? Just help me understand why that's not arbitrary.
Absolutely, Your Honor. It's not arbitrary because in that circumstance, the court granted the petitioner's motion for continuance, thus alleviating that unfair surprise or prejudice after that expert had been designated because they were able to take the deposition. In this case...
Could you have deposed their newly designated expert? You had more than about a month.
Not quite a month, Your Honor. I'll explain why. Absolutely, we could have deposed the expert sometime in the 34-day period.
Yeah.
But that doesn't...
And so, it'd be different if this was sort of the eve of trial or mid-trial, but that coupled with the fact that the expert that went to Ohio's deposition took place before there were opinions about is it Dr. Wheathorn or?
Dr. Wheathorn, correct.
Yeah, so his opinions came later, right?
They did.
So the deposition, even if they had decided to preserve trial testimony and ask their expert questions, would not have been complete because there was additional expert testimony taken.
That's not the case, Your Honor.
That's not the case, okay.
Because the substance of the deposition testimony that Dr. McFarland testified about in this 143-page deposition that Diamond never used at trial, the substance of that opinion regarding the cause of the spherical bearing was in here, regardless of the crane operation, regardless of the type of material they used. Diamond had this at its fingertips, and it simply chose not to use it. That's not good cause. That's not lack of unfair surprise or prejudice. And to Justice Hawkins' point, good cause would require a greater establishment than these strategic decisions by counsel.
I would understand that more if there was not adequate time to depose the new expert. But given that there was, why does it defeat good cause to say, well, they have other lesser substitutes, given that you were sufficiently far out from trial to take a deposition?
Right, and there's a nuanced distinction there, Justice Bland. The good cause analysis is not a function of the time frame between now and trial. That's more of a function of the reasons that the expert has been made unavailable. The unfair surprise and prejudice is not alleviated just because you can take a deposition. The party responding to the untimely automatically excluded evidence could take a deposition the night before trial, but there's going to be no way to get the transcript, then you have to compare the credentials of the witness.
Well, that's the prejudice part, right? But if you're
Absolutely.
34 days out or a week out or 15 days out, you don't have that, so the prejudice goes down.
The prejudice does go down, but it did not get decreased sufficiently to where it was eliminated, Justice Young. And here's the nuance factually and temporally as to why it wasn't 34 days. On September 2nd, that's when we found out that he was going to be somehow, Dr. McFarland, the 540-day late expert, was going to be somehow moving to Ohio and switching jobs. That's not categorical unavailability. As counsel for the petitioner mentioned, all the declaration said is, I'm not available to testify for a jury trial starting October 3rd, 2022.
And I have no plans to return, and you have no authority to accept a subpoena on my behalf.
Correct. But that does
sounds
not,
pretty unavailable.
that's unavailable, but that's not unavailable. It's unavailability for that one trial setting. And we offered
Well,
at
what
that point.
about no plans to return and you can't accept a subpoena is limited to that trial setting?
What was confusing at that stage was that somehow they could get Dr. McFarland on the phone. Somehow they could get him to sign a declaration or an affidavit, but they couldn't get him to appear at the September 16th, which was 17 days before trial, thus bookending the lack of continuance and the unfair surprise or prejudice.
When they get him on the phone, it's to say, I'm not coming.
Okay?
I mean, that doesn't seem that hard. People can get me on the phone. For me to tell them I'm not going to do something a lot easier than they can get me to come and do the thing I just told them I'm not going to do.
Sure. And had we had that evidence, if that was in the record, that would change the circumstances and at least shed some light on what we needed to do. But instead of that, at that date, September 16th, there's no evidence in the record. Dr. McFarland just no-showed for the hearing.
I never heard your answer to Justice Sullivan's question about what's good for the goose is good for the gander.
Right. The difference between when we had our expert substituted and when Diamond had its motion for leave denied was when Diamond had its motion for leave denied, it is a chronological fact that the trial had gone that long. They had already moved for continuance 3 times at that point. The 3 strikes are out, Justice Sullivan, that you mentioned, or however many it was, they had already gotten a continuance to depose Dr. Weethorn. And after several trial settings, there are 3 continuances in total, 3 trial settings. The middle continuance was sua sponte by the court because we were only number 2 on the docket. And then that 3rd continuance, enough was enough. So the distinction between, okay, Austin Crane gets its rebuttal expert in several hundred days past the deadline, and Diamond Hydraulics does not, is because it is a chronological fact that the fact this has gone on for so long, and the fact that Dr. McFarland, the first untimely designated expert, was because they had moved for continuance twice, putting into that position. If the petitioner had raised an abuse of discretion as to the denial of that motion of continuance, we'd be making very different arguments. That's not the issue before the court.
If we could come back to the question about Zoom, kind of the same questions that I asked of your friend in opposition. Why on earth, maybe this is just because I'm too much of a Luddite, but why on earth would it matter that Dr. McFarland could have appeared via Zoom in the courtroom, even though he's not there and everybody's going to talk over each other and my son's going to have to show me how to dial in?
Because it would help establish a record of good cause. And instead, there's a very threadbare record of leaving the state, not accepting a subpoena. And then what happened at September?
Wait, how would it help establish good cause?
Because Dr. McFarland could provide testimony to the court as to why he can somehow appear to a Zoom hearing, but he can't appear for a Zoom trial deposition between September 2nd, when the alarm bell was sound, and the September 16th hearing. It would at least give us some information, and then we can make a determination at that point. Instead, there's nothing.
They had another expert. They designated somebody else in his stead.
I mean, it kind of seems like, again, sauce for the goose, sauce for the gander, as Justice Lerman said. It seems like, again, of course, the district judge is the master of his or her courtroom and the ample discretion, as Justice Hawkins has said. But, the NBA refs, okay, they're calling it easy this one, go foul them. Okay, and this one, the 3-point shooters are going to get it done. And it seems like there is, like you say, kind of a course of conduct. But it seems like the course of conduct was they're not calling any ticky-tack fouls in this one until all of a sudden they were. And so what changed?
I think it's not so much as to what changed, Your Honor, as to what was consistent. And what was consistent was litigation choices and failures on the part of Diamond Hydraulics. Diamond Hydraulics made the litigation choice not to ask questions at the deposition. Diamond Hydraulics made the litigation choice not to call Dr. McFarland by trial by deposition. Diamond Hydraulics was offered to take the Zoom deposition and refused. And we even offered to allow Dr. McFarland to appear remotely at trial, but Diamond also refused.
Was it Diamond that refused, or was it Dr. McFarland that refused?
Yeah, he was never one of their employees, and they can't, impress him into service, put him on the chain gang. We have a 13th Amendment to the federal Constitution, so.
There's evidence of emails in the record of us making those offers. The trial court would have permitted it and mentioned that at the hearing. That simply never happened.
Yeah, but I mean, you can offer things all you want, but if the only person who can make it happen says it's not going to happen, what difference does any of that make?
Well, the solution at that point, Justice Young, would be, again, to use the deposition. And counsel for petitioner mentioned...
Do you think that that's an adequate substitute?
Yes.
You're willing to, maybe your next trial, just abandon the live witness and use a deposition?
Yes.
You're willing to do that?
Because it's fair to the other responding party.
I just mean in general. Your next trial, nothing about the other person losing it. Instead of putting on your live expert, just introduce the deposition to the jury. You're agreeing that you'll do that in your next trial?
If the court binds me to that situation, absolutely. Because it's...
Well, no, we were talking about strategery, and I'm sure that your friend in opposition will be able to stand up and throw rocks at some of the strategic decisions that Austin Crane's good counsel made here. But I think that clearly it's hypothetical. But I think Justice Young's, to build on it, your next trial, okay, we're inside the courthouse, and we've got a battle of experts as you started with, and we're going to do a blend. We're going to have a couple of maybe a deposition transcript for one, and then on the other one, the guy's going to get on and say, "Oh, sorry, you're muted. Oh, please mute your line. Uh-oh, somebody used the potty and didn't mute their line." That is a strategic decision that you or any other able trial lawyer would ever do, ever?
I think it would be unrealistic to take the position that I would prefer to have a deposition or somehow a Zoom as opposed to live testimony.
Okay.
But the reason that was fair here, and Rule 193.6 sounds in fairness, is because if the court did not apply that automatic exclusion, it would shift these problems that Diamond Hydraulics caused onto Austin Crane's plate. Diamond's litigation failures, Diamond's inability of it to get its witness from coming back from out of state, Diamond's choices not to ask questions of the deposition, Austin Crane's problem.
Can I ask? Oh, I'm sorry. Please go ahead.
Excuse me, Your Honor. That is not the point of 193.6. The point of 193.6 is to protect the responding party. I beg your pardon.
If I go back and print out one opinion from our court and read it real careful with my stuff, with the technology that I understand, which one would you want me to print and go and do that? And I'll ask the same of your friend in opposition.
Farah versus Alvarado. Farah versus Alvarado, Your Honor.
Okay.
And the reason for that is...
I have that one. I've already done that one. Okay, got it.
Very good. The reason I say that, Justice Sullivan, is because that sets the standard, which has remained undisturbed for over 30 years.
Oh, I'm sorry. Alvarado I have, because the good cause standard of 193.6 and its predecessor in 215.5. I'm saying on the abuse of discretion standard. So this is not one about just, Rule 193.6 or anything. Like your very, very best that I should print and do on what we understand the abuse of discretion standard to require here, and then I'll ask for the same of your friend in opposition.
Absolutely, Your Honor, and I'll point your attention to the Court of Appeals case that it cites to the abuse of discretion standard in the State Farm case.
State Farm? Okay.
Absolutely, Your Honor. And for the record, that says a trial court abuses its discretion if its ruling is arbitrary and unreasonable without regard for any guiding legal principles or supporting evidence.
And what year did we decide that one? It's probably cited, but
I don't have that off the top of my head.
That's fine. I'll find it in the
It's in the Third Court of Appeals opinion.
How about...
okay.
Oh, please.
No, please.
As an additional case, what about the Euless Pizza case, where we said that good cause is established by showing the failure involved was an accident or mistake, not intentional or the result of conscious indifference, and that this is not a high bar?
Sure. Those circumstances are very different, Your Honor.
We're not talking about different circumstances right now. I'm just talking about what the right standard is. And it seems as though we've said some things about what we mean by the textual requirement of good cause, and that the standards are not all the same. Why is it that we should go with the very old one and not our more recent explanation?
and I don't mean to argue with you, Justice Young, but it's because of the circumstances as to why the standard in Euless Pizza should not be adopted here.
Okay.
The standard in Euless Pizza precluded the party from a trial because it was deemed admissions. The party, I think, got it 1 day late, and those deemed admissions prevented that party from having a case whatsoever. A mere temporal bar prevented it from having a case whatsoever. In this case, Diamond had a trial. Diamond had the ability to put on evidence, and the bearing theory was before the jury. So the standard of accident or mistake, and to lower it to that low bar, is not what this court should do. Even if it does, there was not an accident here. There was not a mistake here under Euless Pizza.
Well, from the perspective of your friends on the other side, it's kind of an accident, isn't it? I mean, losing your expert, having him move to, why anybody'd move to Ohio from Texas, I don't know, but it happened.
Your Honor, there were conscious decisions that were not inadvertent along the way. As I've mentioned, not calling, or I don't think I've mentioned yet, John Barrett was their first causation expert. They designated him. That was an accident. That was an intentional decision. I don't know why. They made a conscious decision that was not an accident or mistake, not to ask their expert questions at a deposition. They made the conscious decision not to take this deposition and offered at trial. As Justice Lerman mentioned, why wouldn't that be enough? It would be. Counsel for Petitioner mentioned opinion 4. It's not in the record. This is page 998, which is from his report. The opinion is, the bending of the hydraulic cylinder was a consequence of the seizing of the spherical plane bearing at the rod end.
Did the new proposed expert, did Diamond Hydraulic agree to limit that new expert's opinions to those that were contained in Dr. McFarland's report?
It did not agree to limit them, and I don't even know if that's a promise they could keep. It agreed to adopt those opinions and to adopt all the testimony. But practically,
I could see the surprise being magnified if a new expert was going to offer new or different opinions.
correct.
But you had expert reports, and presumably everybody knew what the opinions were.
Correct. But as a practical matter, Dr. Horner is a different human being with a different PhD. He was a metallurgical engineer as opposed to a mechanical engineer. The differences in those opinions, the differences in the way they would characterize the testimony, comparing Dr. McFarland to Dr. Horner, somehow comparing their qualifications, trying to determine if they can meet the Robinson factors, and potentially moving to strike that expert 17 days before trial when the court has already denied the motion to continuance. The burden on Austin Crane to do all of that, because of Diamond Hydraulics doing, would have been enormous.
It seems strange for me to hear you say, well, he's just such a different person, all these different expertise, all that stuff, but also to say, well, it's cumulative.
Fair point, Your Honor. And what was cumulative is not Dr. Horner's testimony, because that is not part of the record.
Here's the heading in your brief on page 50. Dr. Horner's testimony was cumulative.
Dr. Horner's testimony, I see. The difference in what I just said and what you're asking about, Justice Young, is Dr. Horner was going to adopt the report and the testimony about the bearing. There was evidence in the record before the jury, all over the record, about the bearing. 52 pictures of the bearing. The actual spherical bearing itself showing light spalling on the front. Diamond cross-examined Dr. Weethorn about the bearing. Diamond cross-examined Mr. Studer about the bearing. All of the information and evidence that Dr. Horner would have testified about was before the jury. The jury heard the bearing theory. The jury considered the bearing theory. The jury rejected the bearing theory in its verdict, deliberating for less than 2 hours. And that goes to one of the large points.
Your time has expired.
Oh, excuse me, Your Honor. Thank you very much.
It's all right. Any further questions? Thank you. Ms. Alalde, you have 5 minutes.
Start with just a quick yes or no question. So if we stick with Alvarado's difficult or impossible standard, do you lose this case, yes or no?
Absolutely not.
Okay, thank you.
Sorry, that was 2 words. Absolutely not. Those exceptions absolutely apply on these circumstances, this record, and then the due process concerns. I don't know that, I think a lot of lower courts are just thinking, well, it's an automatic sanction, so you don't even have to worry about Trans-American, you don't have to worry about due process, and it should be very clear in our jurisprudence that any kind of merits preclusive discovery sanction, you gotta think about that. We can't have more protections for intentional discovery abusers than we have for people who just encounter, a series of unfortunate circumstances.
It says it's not merits preclusive, though. I mean, it's certainly not the merits presentation that you would want, but it's not merits preclusive because you do have all the images he just talked about, the depositions. Yeah, it's not as good as having a live expert, but it's not merits preclusive.
I would ask, Your Honor, to look at our brief. You'll see a side-by-side. The report with all of these images that was entered into evidence, you'll see a bunch of black pages. Every single opinion is redacted. So what you see are some pictures of a spherical bearing with zero explanation, which is the exact reason why we had to designate somebody and why they had to tear the hydraulic cylinder apart to test it to figure out why in the world did it bend, and it wasn't just metal. A couple of very quick, I know that Justice Sullivan, you asked about an opinion. I'd asked the court to look at Wheeler versus Green, which is cited in our case, in our briefing. Going back to the deposition, a couple more record sites to show why it is not sufficient. The record wasn't clear. We have a transcript, right? It's just cold record. Pages 1538, 1539, we've got Dr. McFarland saying, well, I'm trying to explain this part of my opinion. I think it's in figure 62 over here. Oh, wait, nope, that's not the right one. Down, down, down. Oh, okay, it's right there. There is no way we could have sat in a chair, read that testimony, read that transcript to a jury and have them understand what it was he was trying to talk about. It just would not have been able to, again, explain the merits of our defense to a jury. Also in the record at page 1271, volume 3 of the clerk's record, the first contact was 34 days before trial on August 30th. And then there was also evidence in the record beyond the affidavit. And that came through the statements of counsel and through a verified motion for continuance or for reconsideration that also further explained his unavailability.
What is the broader rule that you think controls here? Like a trial, like divorced from the facts of this case, a trial court abuses its discretion and violates Rule 193.6 when blank.
A, it refuses to consider the evidence in front of it that would establish good cause. And establishing good cause in that is difficult or impossible circumstances under Alvarado, beyond your control, should amount to difficult or impossible circumstances. And I'm sorry, the second part of your question?
Oh, no, that was it. Just
okay.
What's the broader rule of law?
For good cause, absolutely. For unfair surprise or prejudice, it seems like that would even be slightly looser, considering the timing situation that we had here.
And does it need to be cabined to something that's, if not merits preclusive, at least debilitating of the merits, or does that part not need to be in the rule?
I think that there is, it doesn't have to be merits preclusive. In re Garza kind of talks about this. We had a car accident case. The treating physician was not supposed to, was excluded from testifying. The court ended up saying, listen, it's not a death penalty. It's not exactly a death penalty, but you know what? It was a really big part of the case, and that's enough to be harmful to the plaintiff in that case. And then on the cumulative point, very quickly, Gunn v. McCoy talks about this whole cumulative issue. And it cautioned, it's not to say that a plaintiff can put their expert up first and say, oh, I'm just going to talk about what the defense expert was going to talk about, and then say, oh, you don't get defense testimony because that's cumulative. And that's something that this court has specifically cautioned against.
Last term, I think Justice Per Curiam had an opinion in In re Newkirk, where we broke out the big stick on extraordinary mandamus relief for an abuse of discretion for death penalty sanctions in a case. What is your kind of elevator pitch for why this case and what happened here is death penalty in the same way that a case like Newkirk was? Like, death is different, but tell me what's the pitch?
The pitch is, if you can't, there's no reason to go through a trial if you can't even present your evidence. right? And so the death penalty sanction there and the reason that mandamus would be appropriate would be you really don't have much of an adequate remedy. It's very difficult to show what you wouldn't have shown. And here we've done it through an offer of proof.
Thank you.
Any further questions? Thank you, Ms. Alalde. Thank you to all counsel. The case is submitted. That concludes the arguments set for today. The marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.